The Department of Justice has resumed enforcement of the Foreign Corrupt Practices Act, but with a new, sharper focus that could have consequences for U.S. exporters. I'm Kari Crane, editor of Shipping Solutions International Trade Blog Passages. Before we dive in and explain what you need to know to stay compliant, not just with how this administration is enforcing the law, but with the full scope of the FCPA, make sure you subscribe to our channel. We publish basics of exporting and importing videos twice a week to help you simplify international trade. After a pause in enforcement activity, the Department of Justice issued updated guidance realigning its FCPA priorities with broader U.S. national security and economic goals. The big takeaway is that enforcement is back, but it's more targeted. DOJ prosecutors are now directed to focus on serious corruption that harms U.S. interests, including bribery tied to cartels or transnational criminal organizations, foreign bribery schemes that disadvantage U.S. companies, corruption involving critical infrastructure, defense, or intelligence sectors. All new investigations require high-level approval within the DOJ, signaling a more deliberate, centralized strategy. Another significant shift is a greater emphasis on prosecuting individuals rather than corporations. Foreign officials who solicit or accept bribes may now face charges under the Foreign Extortion Prevention Act. Prosecutors have also been told to focus on major violations, not minor infractions. They're prioritizing cases with large or repeated bribes, sophisticated efforts to conceal wrongdoing, obstruction of justice, strong, clear evidence of corrupt intent. Routine business courtesies or low-dollar payments are no longer enforcement targets unless they point to a deeper pattern of misconduct. The Foreign Corrupt Practices Act has two key provisions that U.S. exporters and multinational businesses need to understand. Anti-bribery provisions prohibit offering anything of value to a foreign official to gain a business advantage. This applies to U.S. companies and individuals, even abroad, foreign persons while in the U.S. Penalties reach millions of dollars in prison time for individuals. There's a narrow exception for grease payments to facilitate routine government actions. The accounting provisions enforced by the SEC require companies to maintain accurate, detailed records, implement internal controls to detect and prevent corruption, conduct regular reviews of transactions and assets. Civil penalties can exceed $1 million per violation, depending on the case. Although the DOJ is now applying the FCPA more selectively, the law itself hasn't changed, so exporters should not relax their compliance standards. Violations can still be prosecuted years after they occur, so if enforcement strategies change with a new administration, you don't want to be caught off guard. Plus, many U.S. trading partners, including the UK and EU, have their own anti-bribery laws that apply regardless of U.S. enforcement priorities. Your best protection is still a well-documented, fully implemented compliance program. We can help with that. Click here to download our free guide, How to Create and Implement an Export Compliance Program, and watch this video to learn about your compliance responsibilities. And for even more resources, check out the hundreds of articles on exporting and compliance available on the International Trade blog, linked below.